Good afternoon. On behalf of Superintendent Hoffmeister and the Office of Federal Programs, I would like to welcome you to today's webinar on dispute resolution for homeless children and youth. My name is Tammy Smith, and I'm a program specialist here in the Office of Federal Programs. Today, we're going to go over a few definitions. We're going to talk about dispute resolution procedures and tips for establishing an effective dispute resolution process for your district. Just a few basics to start with. The Every Student Succeeds Act, or ESSA, was signed into law on December 10th, 2015. ESSA reauthorized the Elementary and Secondary Education Act, ESSA, and the Education subtitle of the McKinney-Vento Act, and all ESSA provisions currently are in effect. Homeless children and youth have the right to attend the school of origin, which is the school that a child or youth attended when permanently housed, the school in which the child or youth was last enrolled. This includes public preschools, and it also includes the receiving schools. They also have the right to attend the local attendance area school, which would be any public school that non-homeless students who live in the attendance area in which the child or youth is actually living are eligible to attend. The term school of origin means the school that the child or youth attended when permanently housed, or the school in which the child or youth was last enrolled, including a preschool, and there's the law there for that. Does McKinney-Vento requirements apply to homeless children attending preschool? To the extent that an LEA offers a public education to preschool children, including LEA-administered Head Start programs, an LEA must meet the McKinney-Vento Act requirements for homeless children in preschool, including ensuring that a homeless child remains in his or her public preschool of origin, unless a determination is made that it is not in the child's best interest. Okay, and that comes from the non-regulatory guidance. So receiving schools, when the child or youth completes the final grade level served by the school of origin, the term school of origin shall include the designated receiving school at the next grade level for all feeder schools. And then best interest determination. In determining school placement in the best interest of the student, the school district shall presume that keeping the child or youth in the school of origin is in the child or youth's best interest, except when doing so is contrary to the request of the parent, guardian, or unaccompanied youth, and should also consider student-centered factors related to the child or youth's best interest, including factors related to the impact of mobility on achievement, education, health, and safety, giving priority to the request of the parent, guardian, or unaccompanied youth. In fact, under ESSA, they have used stronger wording around presumption of best interest and keeping the homeless students in the school of origin. They have also used stronger wording about prioritizing the views of the unaccompanied youth. And they have, ESSA removed the phrase to the extent feasible. Okay, so they're, when all possible, they are saying if it's in the best, that it's in the best interest of that homeless child to stay in the school of origin. For preschoolers, things that you might consider for their best interest, factors listed in the statute, the impact of school climate on the child, including the school's safety, the availability and quality of services to meet the child's comprehensive needs, including health, developmental, and social emotional needs, and the travel times to and from school. And then, of course, these would also be things that you would keep in mind for other students than just the preschoolers, as well as what kind of relationships do they have at that school? How would breaking those relationships to put them in a different school matter? How are they doing academically? Are they achieving or making progress, and how would that be affected if they were moved to another school? So there's a lot of factors that you want to look at when looking at the best interest for that student. Duration of rights. Homeless children and youth have the right to attend the school of origin for the duration of homelessness. So in any case in which a family becomes homeless between academic years or during an academic year, they can stay at that school of origin for the duration of their homelessness or for the remainder of the academic year if the child or youth becomes permanently housed during an academic year. So if they are identified as homeless at some time during that school year, they are eligible to remain at that school of origin until the end of the school year, that school year. At the beginning of the following school year, then they would need to attend the school in which the attendance area that they live in, or the school that the non-homeless students that live in that area would attend. Dispute resolution. If, after conducting the best interest determination, the district determines that it is not in the child's or youth's best interest to attend the school of origin or the school requested by the parent, guardian, or unaccompanied youth, the district must provide the parent, guardian, or unaccompanied youth with a written explanation of the reasons for its determination in a manner and form understandable to the parent, guardian, or unaccompanied youth, including information regarding the right to appeal. The child or youth shall be immediately enrolled in the school in which enrollment is sought, pending final resolution of the dispute, including all available appeals. Students must receive all services for which they are eligible until final resolution of all disputes and appeals. So in other words, you can't keep the child from attending that school or hold them out of school while they go through all the dispute process. They need to be immediately enrolled and attending that school until the dispute has been resolved. Section K of the Education for Homeless Children and Youth Non-Regulatory Guidance addresses the issue of dispute resolution, including best practices for developing a fair, timely, and effective dispute resolution process that is accessible to families, minimum standards for what should be included in the written notice, what types of situations fall outside the parameters of the McKinney-Vento dispute resolution process, and implementing an informal process as an alternative to formal appeals while still providing access to the formal process as needed. So we're going to kind of dive into what this non-regulatory guidance addresses here. So K1, under the McKinney-Vento Act, are states required to have procedures to resolve disputes regarding educational placement of homeless children and youth? Yes. Every state must have procedures for the prompt resolution of disputes regarding the educational placement of homeless children and youth. In addition, some LEAs have their own written dispute resolution policy that describes procedures for resolving disputes at the local level. Secondly, what procedures must an LEA follow if a dispute arises between a school and a parent, guardian, or unaccompanied youth, or guardian regarding eligibility, school selection, or enrollment of a homeless child or youth? So if a dispute arises over eligibility, school selection, or enrollment, the LEA must immediately enroll the homeless student in the school in which enrollment is sought, pending final resolution of the dispute, including all available appeals. And on all of these, I've put the sections of the law that, for you to look at if you have further questions about that. The dispute resolution policy should also consider that the statutory definition of enroll and enrollment includes attending classes and participating fully in school activities. Therefore, dispute resolution procedures at the LEA should address barriers to attending classes and fully participating in school activities. Homeless families and youth may be unaware of their right to challenge placement and enrollment decisions. Therefore, the LEA must provide the parent, guardian, or unaccompanied youth with a written explanation of the appeal rights. The LEA must refer the unaccompanied youth, parent, or guardian to the local liaison who must carry out the dispute resolution process established by the SEA as expeditiously as possible. The local liaison should assist the child and family in preparing the appeal and should make the resources of the school, such as copying, mailing, or obtaining records that are needed, available to the parent, guardian, or unaccompanied youth. Number 3, what elements should be included in the written explanation of the enrollment decision and the right to appeal this decision? If a dispute arises over eligibility, school selection, or enrollment in a school, the parent, guardian, or unaccompanied youth must be provided with a written explanation of any decisions related to eligibility, school selection, or enrollment made by the school, the LEA, or the SEA involved, including the rights of the parent, guardian, or unaccompanied youth to appeal such decisions. Notice and written explanation from the LEA about the reason for its decision at a minimum should include the following: an explanation of how the school reached its decision regarding eligibility, school selection, or enrollment, which should also include a description of the action proposed or refused by the school, an explanation of why the action is proposed or refused, a description of any other options the school considered, and the reasons why any other options were rejected. A description of any other factors relevant to the school's decision and information related to the eligibility or best interest determination, including the facts, witnesses, and evidence relied upon and their sources, appropriate timelines to ensure any relevant deadlines are not missed, and contact information for the local liaison and state coordinator, and a brief description of their roles. Fourth, how can an LEA ensure that the written explanation of its decision or determination and the notice to appeal is in a manner and form understandable to a parent, guardian, or accompanied youth? The LEA should ensure that all decisions and notices are drafted using language and formatting appropriate for low literacy, limited vision readers, and individuals with disabilities. For children and youth and/or their parents or guardians who are English learners or whose dominant language is a language other than English, LEAs must provide translation and interpretation services in connection with all stages of the dispute resolution process, consistent with the requirements of the Equal Education Opportunities Act and Title VI of the Civil Rights Act of 1964. If the parent, guardian, or unaccompanied youth has access to email, the LEA should provide notices electronically followed by a written notice provided in person or sent by mail. K5, what types of situations fall outside of the parameters of the McKinney-Vento Act dispute resolution process? Not all eligibility or enrollment disputes initiated by a parent, guardian, or unaccompanied youth are eligible to go through a dispute resolution process at the LEA or SEA level. For example, when the child or youth is not residing in a homeless situation in the boundaries of an LEA, but the parent, guardian, or unaccompanied homeless youth seeks to initiate an enrollment dispute in that particular LEA, that's not something that would fall under this dispute resolution procedure. Or another example, if a parent, guardian, or unaccompanied youth wish to use the dispute resolution process to resolve a disagreement that is unrelated to the McKinney-Vento Act, such as a special education issue. In these cases, the LEA should refer the parent, guardian, or unaccompanied youth to the program or administrator that would more effectively address that particular complaint. K7, what are the effective strategies for LEAs and SEAs to use to resolve enrollment disputes? LEAs and SEAs should consider the following strategies for effectively resolving disputes. Resolve disputes at the district level rather than the school level. Create an option for an informal process as an alternative to formal appeals, which should be in place but must not waive the parent guardians, or unaccompanied youth access to a more formal process if the informal resolution is not successful. Inform parents, guardians, and unaccompanied youth that they can bring a lawyer, a non-lawyer advocate, or any other person to assist them in such a proceeding or appeal. Ensure that any written notice is complete, as brief as possible, simply stated, tailored to limited literacy readers, and provided in a language and format that the parent, guardian, or unaccompanied youth can understand. When inter-district issues arise, ensure representatives from all involved districts and the SEA are present to resolve the dispute. A state-level appeal process involving the state coordinator should be available for appeals of district-level decisions and resolution of inter-district disputes. And any communication to the state coordinator should be provided to all parties involved to ensure fairness. The dispute resolution process should be as informal and accessible as possible, including not requiring unnecessary notarization or authentication of documents or other materials submitted, not requiring strict legal evidentiary standards, and allowing for impartial and complete review. Parents, guardians, and unaccompanied youth should be able to initiate the dispute resolution process directly at the school they choose, as well as at the district or local liaison's office. Districts should establish timelines to resolve disputes at the local and state level. The dispute resolution should be prompt, but not sacrifice equitability and fairness. Parents, guardians, and unaccompanied youth should be informed that they can provide written or oral documentation to support their position, and parents, guardians, and unaccompanied youth should be given the opportunity to challenge the school system's assertions. And students must receive all services for which they are eligible until final resolution of all disputes and appeals. And I cannot emphasize that one enough. Okay, so just a few tips for establishing an effective dispute resolution process. LEAs may also consider including the following items and information distributed to parents, guardians, or unaccompanied youth when informing them of decisions regarding enrollment. Give them a notice of the right to file a complaint, raise a compliance issue, or file an appeal. They should get a step-by-step description of how to appeal the school's decision that includes a simple form that parents, guardians, or unaccompanied youth can complete and submit to the school to initiate the dispute process. Copies should be provided to the parent, guardian, or youth for their records. Should be given notice that if the parent, guardian, or unaccompanied youth are English learners, that there will be or they use a native language other than English or need additional supports because of a disability, translators, interpreters, or other support services will be made available without charge in the appropriate language. And given notice of the right to be enrolled immediately in the school in which enrollment is sought pending final resolution of the dispute. Given notice that immediate enrollment includes receiving adequate and appropriate transportation to and from the school of origin and the ability to fully participate in all school activities. They should be given a list of legal and advocacy service providers in the area that can provide additional assistance during any part of the process, and contact information for the local liaison and state coordinator with a brief description of the roles, and timelines for resolving district and state level appeals so that they have some idea of how long this process will be. These processes may include, but are not limited to, any administrative procedures adopted by the LEA for addressing matters such as parent or student complaints, attendance, credit recovery, or grade placement. In some circumstances, additional concerns may be appropriately addressed in an IEP team meeting or a Section 504 placement team meeting. Other appropriate processes may include investigation of matters related to bullying, sexual harassment, or illegal discrimination. Okay, any questions today? No questions? Okay, well, here are the resources that I used to put this PowerPoint together. How soon will the PowerPoint be posted? It will be posted probably, today's Thursday, probably early next week. When will Kickstand be available? Keeping our fingers crossed, we're hoping that those emails go out next week. But I'm not making that promise, just keeping my fingers crossed. You're welcome. Okay, any other questions? This is my contact information. If you have questions about this or anything else, please contact me either by email or phone. And thank you again for spending some time with us this afternoon. Have a great afternoon.